Take your device, place it on a flat surface. Place yourself in the center of the device so that I may be able to see you squarely. And please then refrain from moving. Actually, physically getting up and moving around, it is very distracting. And so please do not do that. If you are in a vehicle, if your name is not displayed, first name and last name, and if your appearance, you don't have your video on, when the court is addressing you or you're trying to address the court and then not in good lighting, I will not recognize you when I call your name. I will tell you what the problem is, and I will give you an opportunity to correct it. At the end of my calling of the docket, then I will ask for those people who I have not recognized, and that is the time that you need to let me know that you have fixed the problem so that I may recognize you. Otherwise, I have marked you as failure to appear. If that stays in my notes, in my markings or the docket, then that's what will happen, and I will issue a warrant. So to avoid that, please make sure that you let me know that you have fixed the issue when I ask you at the end of calling of the docket. Zoom has a chat feature. You cannot chat without my permission, with one exception. Deputy De La Cruz is the bailiff in this court, and he controls the comings and ins and out of the court as well as the Zoom session. So if you have to leave for any reason, please make sure that you chat to Deputy De La Cruz and let him know that you're stepping out, going to the bathroom or something, and that you'll be right back. That goes for you as well in the courtroom. We are operating hybrid. If you need to leave here, make sure that deputy knows that you're leaving. Deputy's name is displayed as the BCSO. That stands for Bexar County Sheriff's Office. He's Deputy J. De La Cruz. That's how his name is displayed. There'll be no chewing gum, eating, drinking, vaping, or smoking while you are on Zoom. If you cannot do it in the courtroom, you cannot do it on Zoom. You cannot leave the Zoom session or the court for the day without my specific permission and excusing you from the court for the day. If you're leaving, make sure that you have 1 or 2 documents in your hand or being emailed to you. 1, a dismissal, or 2, a case setting form telling you when to come back to court. If you do not have either one of those documents, you have not been properly excused from the court. As well as me saying that, yes, you can go. All right, procedurally, I will complete calling the docket. Once I finish calling the docket, then I will move attorneys that need to confer with the ADAs or consult with the court coordinator. Then I will come back and I will address each individual issues. So let me finish calling the docket. We'll move folks to confer. Once we've moved them and they're conferring, then I will be able to address individual issues. As I call the docket, I will call the defendant's name 2 times. If I mispronounce your name, please correct me so I may make my best effort to pronounce your name correctly. You should respond when you call your name and hear your name, here or present. I expect you in the courtroom to stand and respond, here or present, and remain standing. In Zoom, I expect you to unmute yourself. So find that mute button, unmute yourself, respond here or present, stay unmuted so that I may determine who your representation is. I will ask you, who is, is this person your attorney? Please respond yes or no, and let me know so that I may check you in and we may carry on. If you need time to hire an attorney, I see that you don't have an attorney. I will ask you if you have time to hire an attorney, and we will, I will address that with you right after I finish calling the docket. If you need to apply for a court-appointed attorney, I will probably excuse you if you're in the Zoom session so you can come down to the courthouse and we can get that application started. So you'll have hopefully get somebody appointed to you today. You are in the Zoom session. I expect your posture to be as the same as those who are in the courtroom. They are sitting up straight, so I expect you in the Zoom to be sitting up straight. Attorneys, you may go ahead and respond for your client, but please keep in mind, I still need to hear from the defendant in order to be able to check, and I will check both of you in. Any violations of these instructions are subject to contempt of court. Again, today is Monday. It is the 14th day of November 2022, and I am looking for the following people. Jose Alvarado. Jose Alvarado.
Present, Your Honor.
Good morning, Mr. Alvarado. Is your attorney Jaime Aldape?
Yes, it is, Your Honor.
Very good. We'll go ahead and wait for him. I thank you for being here.
Thank you.
Travis Borklund. Travis Borklund, Mark Borklund. Please mark as failure to appear. Joe Frank Harmilio. Joe Frank Harmilio. Mark as failure to appear. Maria Solis. Maria Eva Solis. Mark as failure to appear. Genevieve Gomez. Genevieve Gomez. Mark as failure to appear. Crystal Garcia. Crystal Garcia.
Present, Your Honor.
Okay, Ms. Garcia, I don't know what you're doing on Zoom. You're supposed to be here in the courthouse, and I will go ahead and excuse you to come down to the courthouse. Thank you.
Judge, may I approach? Scott Martinez, I'm attorney for Ms. Garcia.
Oh, hang on 2 seconds. I'm sorry. I'm sorry. I looked at something incorrectly. I take that back, Ms. Crystal Garcia. Yes, sorry about that.
Okay.
I saw something in there, but I wasn't looking in the right spot. Thank you. John Trevino. John Anthony Trevino. Mark as failure to appear. Eric Manchaca. Eric Matthew Manchaca. Good morning, sir. How are you doing? Very good. We'll go ahead and wait for your attorneys. Please call him, tell him he's late. Okay, is there anybody in the courtroom that did not hear their name?
Yes, Your
Okay.
Honor.
In the courtroom,
Oh, I'm
in
sorry.
physically in the courtroom, okay? Anyone now in the Zoom session that did not hear their name?
Your Honor, Mark Braswell with client Andrew Dixon Cabrera. We're a recall from last week on Thursday, the 10th, and we're working on a plea bargain already with Ms. Hahn.
Please give me the last name of the defendant, please.
Cabrera, C-A-B-R-E-R-A.
And you said it was Mark?
It's Andrew Cabrera, Your Honor.
Okay, thank you.
Yes, ma'am.
Andrew Cabrera?
Present, Your Honor.
Very good, thank you. What was the case number, counsel?
Your Honor, it is case number 684-955.
All righty, thank you. All right, anyone else that did not hear their name, I did not recognize? Okay, very good. That will conclude the calling of the docket. Deputy, of course, anyone coming in is extremely late, and so you'll know where to place them. Please let me know if anybody comes in via Zoom as well that has been late. ADAs, I expect you in the courtroom. Thank you. And what is the status of your paperwork, Attorney Braswell? Should I have it?
No, Your Honor, I'm doing it right now as we speak. We just received it from Ms. Hahn and we're going through it now.
Okay, please proceed.
Thank you.
Judge Scott Martinez, may I approach?
Yes, sir.
I believe we have a plea on Crystal Garcia. I believe the paperwork should all be ready, I hope.
Okay, let me go. Let me check for you, okay, sir?
Yes, Judge.
Attorney Martinez, we should be ready shortly. I'm just waiting for the file.
Yes, Judge.
And State, you're going to need a microphone. Do you have the 1622 that's supposed to be associated with this defendant on cause number 679-979? Yes. Morning.
I have one in custody, we have trial. Do you mind if I bring it to the cell? Sorry.
Good morning. And defense, Attorney Martinez, are you aware that there's a 1622 associated with your client?
I am not, Judge.
And we'll see if it's available in discovery.
We have no objections to discovery. Discovery is complete in our opinion, if that's an issue for the court, Judge.
No, it's about the 1622, sir, whether you've seen it. So.
Oh, yes,
Do you
Judge.
have it? Do you have it in your discovery?
Yes, Judge.
The 1622?
I have to go make sure, but I should have gotten it, Judge.
Okay, I mean, then, because I asked you whether you were aware there was a 1622 report associated with your client. And so you said no, so that's why I'm trying to determine whether it was e-discovery and uploaded. Did you want to check, sir?
Yes, Judge. May I speak to confer with the state, Judge?
They're looking to see whether it's uploaded, sir. But if you think that discovery is complete for you, would you check with your discovery what you received and see if it is amongst your paperwork?
Yes, Judge, I will look.
Okay. You guys don't have it.
No, we do. There's nothing to report on.
Okay. Are you able to print?
Judge, we're not allowed to.
No, print it out. I said print. Print it.
We're
Are
not
you?
allowed to disseminate it, like it's state and there.
Could you please look up 1622 report on the Code of Criminal Procedure? But my question is, can you print from there?
No.
Okay. Good morning.
Judge Scott Martinez.
Yes, Attorney Martinez.
I see from my discovery that I have seen a 1622, Judge.
Okay. Alrighty, I'll need for you to be able to address that. Okay, when at the appropriate time, I will ask you about that. Basically, two things I will say to you is one, I will say that I'm going to withhold my finding of competency until you address that. And basically, all I need for you to do is tell me there are no competency issues, or there is maybe. But you would, the 1622 is not particularly regarding a competency as much as any resources that may be required that will benefit your client. Okay, and I'll ask you again when I ask you to speak on behalf of your client. Okay.
Yes, Judge.
Thank you. All righty, state, please, excuse me, in the courtroom. If you guys would like to go ahead and continue conferring, can do that in the jury room or in that back room. I'm about to go ahead and take a plea. All righty, thank you so much. I want you to be able to confer now. Okay.
This is only my personal work right now.
Go ahead, stay here. Get it over there. Let's get on record. Court is going to call cause number 679-979, State of Texas versus Crystal Rodriguez Garcia. Parties, please approach and identify who's before the court, starting with the state.
Victor Hernandez for the state.
Scott Martinez, defense, Judge.
And are you Crystal Rodriguez Garcia?
Yes, Judge.
The same that has been accused of driving while intoxicated with a BAC 0.15 or higher, alleged to have occurred on the 26th day of February 2022 and classified as a Class A misdemeanor. Are you the same so accused?
Yes, Judge.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
Yes, Judge.
Thank you much. You may go ahead and lower your right hand. Court is going to start sharing the court's screen as the state is here in the courtroom. We are operating hybrid as the defense is on Zoom. Ms. Garcia, can you see the court's?
Yes, Judge.
The court screen, okay. Defense, can you see the court screen?
Yes, Judge.
State, can you see the court screen?
Oh, yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign that document that's consenting to these proceedings by video con?
No, Your Honor. Assistant District Attorney Ling Han signed it, but the state adopts it, Your Honor.
The state's video conferencing consent is made part of the record. And State, if you want to maybe move down here so you can see it better, that'd be great. And I can share it with you a little bit better. Defense, on display is a document entitled Defendant's Consent to Video Conferencing. Ms. Garcia, is this your signature where I'm circling the cursor?
Yes, Judge.
Did you sign this document that's consenting to plea by video conferencing?
Yes, Judge.
And counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Judge.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Ms. Garcia?
More than 10 days, Judge.
Are we applying for probation? And if so, what type, sir?
I believe it's deferred adjudication probation, Judge. Yes.
You can see the document on display, counsel?
Yes, Judge.
Then you wish to, at this time, confer with the state, as that is not what the document I have before me.
I apologize, Judge. It's regular probation.
Ms. Garcia, on display is a document entitled Application for Judge-Ordered Community Supervision Probation. This is a 2-page document. This is the first page, and then this is the second page. I draw your attention particularly to where I am circling the cursor in the center of the second page, whereby it states that you appeared before me today. You are the defendant in this case, and I swore you in. Under oath, you're telling me that your application for judge-ordered community supervision probation, as well as the document entitled Personnel Data Sheet, which is going to be attached as an exhibit to your application for probation, is true and correct.
Yes.
Is that so, ma'am?
Yes, Judge.
Do you need to talk to your attorney before you respond to this statement to understand the consequences of your response? That is, the defendant understands and acknowledges that any untrue statement in their application or in the exhibit, that's your personnel data sheet, may be grounds for denial or revocation of your community supervision in this case. Do you wish to speak to your attorney before you respond?
No, Judge.
And so what is your response? Do you understand?
Yes, Judge.
And do you so acknowledge?
Yes, Judge.
Okay, I will sign the document, making it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
Counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
Yes, Judge.
State, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Yes, Your Honor, the state has complied.
Oh, could you bring your, yes.
Yes, Your Honor, the state has complied.
I will sign this discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
Yes, Your Honor, the state moves to waive and abandon the enhancement for alcohol concentration over 0.15 and just proceed on a simple DWI first offense. The state also wishes to waive and abandon the open container enhancement.
No objections, Judge.
So that's, you're moving this, you're proceeding with a DWI first class B misdemeanor?
Oh, yes, Your Honor.
Defense? What
No
say ye,
objections,
defense?
Judge. No objections, Judge.
State's oral motion without objection from the defense is granted. State, any other motions for the court's consideration?
Oh, no, Your Honor.
State, excuse me, defense, any motions for the court's consideration?
No, Judge.
Ms. Garcia, on displays the document entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a two-page document. This is the first page, and then this is the second page. Is this your signature where I'm circling the cursor?
Yes, Judge.
Did you sign this did you go over this document with your attorney?
Yes, Judge.
After you reviewed it with your attorney, did you freely and voluntarily sign it?
Yes, Judge.
So with your signature and testimony, you're telling me that you understand everything in this two-page document as it was reviewed and explained to you by your attorney?
Yes, Judge.
And are you satisfied with the representation of your attorney?
Yes, Judge.
He has done well to bring this to a conclusion for you today. And that's it. Did he go over the range of punishment in this case with you?
Yes, Judge.
Did you understand it?
Yes, Judge.
Did he go over your constitutional rights?
Yes, Judge.
Did you understand those?
Yes, Judge.
Well, understanding your constitutional rights, do you freely and voluntarily give them up?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
I will approve your jury waiver. I'm going to sign it. I am going to make it part of the record, and therefore you will no longer be able to have a jury trial in this case. Counsel, with the information, were you able to apprise this defendant of the nature of the offense and charges against him?
Yes, Judge.
Do you and this defendant waive the formal reading of the information?
Yes, Judge.
State, what is the punishment recommendation in this case?
Under the punishment recommendation is 180
A little
days.
louder, please.
I'm sorry?
Just a little louder.
Oh, yes, sir. Yeah, punishment recommendation is 180 days in jail, probate over 20 months, and 48 hours of community service, DWI education.
24 community service?
I'm sorry, 48 hours of community service,
Okay.
DWI education, U-Impact, TAIP evaluation, ignition interlock for half the term, and a $60 restitution payment to Department of Public Safety.
What was the fine?
There was no fine, Your Honor.
You understand that you still have to state that as far as recommendation? 0 fine plus court costs?
Oh, yes,
Is
sir.
that what you're indicating?
Yes, Your Honor, that's correct.
Counsel, is that your understanding of the state's punishment recommendation to the court?
Yes, Judge.
Or no, it's me, John. I was wondering the conditions can we discuss those or this is just the final?
Can you get him muted? Thank you. Couldn't find mine. Sorry about that. Counsel, I already asked you if that was before the interruption. Did I ask you whether that was your understanding of the punishment recommendation of the state?
Yes, Judge, we agree, Judge.
Ms. Garcia, is that your understanding of what your attorney has worked out with the state on your behalf in order to resolve this matter for you today?
Yes, Judge.
And with that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
No contest, Judge.
Do you understand that even though you're playing no contest, I can still find you guilty?
Yes, Judge.
And you still wish to proceed?
Yes, Judge.
After you've reviewed all this matter with your attorney, correct?
Yes, Judge.
After doing so, you wish to go ahead and plead no contest, then thereby telling this court that you do not wish to fight any of the charges in this case?
Yes, Judge.
And after discussing with your attorney, you feel that your plea of no contest is in your best interest?
Yes, Judge.
I will accept your plea of no contest, finding that it is intelligently and freely made. Counsel, I withhold my finding of competency until you address the 1622 that's associated with your client.
Yes, Judge.
Proceed, please.
My client has been able to assist me with the case. I do not have any mental health issues, problems. I'm confident my client understands what's going on, Judge.
You don't have any mental health issues?
My client does not, Judge, no.
Okay, all righty, thank you. All righty, I will find you competent. Counsel, what if anything about your client, and why should I consider this plea? And please address if there's any matters, resources that would benefit your client regarding the 1622 in the report that you have.
I don't think there's any need for that, Judge. I think she's competent, Judge.
Anything else, counsel, regarding your client in this plea? Why should I consider this plea?
She is very remorseful about what happened, Judge, and we want to move on and move past this incident, Judge, and we're confident that probation will be complete and that you won't have any issues, Judge.
Thank you, counsel. Ms. Garcia, whom do you live with?
My husband and my 2 children.
How old are those children, please?
They are now 15 and 16.
Does your husband own a vehicle?
He has a company trailer, a big truck.
Okay. It's a truck?
It's a CDL.
That's a type of a license? It's a commercial driver's
Yes.
license? He
Yes,
has
Judge.
a commercial driver's license?
Yes, Judge.
So the vehicle you're speaking of is a trailer or 18-wheeler of some sort?
Yes, Judge.
Tractor? A tractor? Okay. How many vehicles are in the household?
2.
So who owns the other one?
He does as well, but I use the the small
Okay.
truck.
All right. What is your husband's name?
Richard Garcia.
Do you have the ignition interlock on your vehicle at this time?
No, I do not, Judge.
Say, what was the VAC in this case?
It was a 0.29.
Has there been any prior cases such as whereby obstruction or anything?
None that I see, Your Honor.
And there was no accident in this case.
Yes, Your Honor, I think it was a single vehicle accident. Double check here. Yes, Your Honor, it looks like it was a collision with a guardrail.
The city is not asking for any restitution.
No, Your Honor, there's nothing I see.
Counsel, is there any legal reason why sentencing cannot be imposed today?
No, Judge.
Ms. Garcia, I'm going to find you guilty of DWI first, Class B misdemeanor. That's driving while intoxicated first. I'm going to sentence you to 180 days in Bear County Jail. I will suspend that sentence and probate it for the next over 20 months. You will be supervised on behalf of this court by the Community Supervision and Corrections Department. With the following conditions: 0 fine plus court costs, 48 hours of community service restitution, DWI education, uimpact.com, TAP evaluation, parenting class. Ignition interlock will be installed within the next 10 calendar days. $60 restitution to Texas Department of Public Safety. I'm going to require 2 affidavits from you within the next 10 calendar days. One from you that states that you will not drive any vehicle that's not equipped with an ignition interlock. The second one will be from your husband, Richard J. Garcia, whom you've identified as your husband, and has a vehicle. He will provide an affidavit that states that he will not allow you to drive his vehicle under any circumstances. Otherwise, I will order an ignition interlock to be placed on that vehicle. He will also identify his vehicle by year, make, model, license plate, year, make, model, color, license plate number, and the last 6 digits of the vehicle identification number. I will have your community supervision officer provide a status report in 2 months, conduct a field visit. And I am going to set your supervision fee at $60. State, did I cover everything for you?
Yes, Your Honor.
Counsel, anything further in this matter?
No, Judge.
Okay. Ms. Garcia, with regard to trial court certification of defendant's right to appeal, this has been a plea bargain case, and I am going to certify that you have no right of appeal. Now, you'll need to come down and provide us a fingerprint. When will you be able to do that? Today is Monday. Will you be able to do that tomorrow, Wednesday, or Thursday, or Friday?
Wednesday, Your Honor.
Now, understand that you'll be coming down to County Court at Law Number 2 between the hours of 2 p.m. not before 4:30 p.m. Excuse me, and before 4:30 p.m. Again, you'll come at between the hours of 2 p.m. and before 4:30 p.m. You'll be coming down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. If you do not come down, but at that time on Wednesday, Wednesday, the 16th of November, 2022, a warrant will be issued for your arrest. Do you understand that?
Yes, Judge.
When you come, you just check with the bailiff and he will direct you further, okay?
Yes, Judge.
All righty. I'm sure this has been a very frightening and horrific experience for you, considering, you know, an accident was involved. Will you move on? It's a bump in the road. Hopefully, you'll understand the seriousness of this matter as you have two precious children who are quite dependent upon you, I'm sure. And take the classes that you will be taking seriously. If you need some other assistance, please communicate with your community supervision officer, and she or he will be able to go ahead and assist you. I'm personally looking for not only your successful completion of probation in this case, but with life. That was a pretty high BRAC of breath alcohol concentration or blood test result. So don't know what all was going on, but I do wish you the best of luck, Ms. Garcia. Okay, let us
Thank
know
you.
if there's anything that we can be able to do to help you be successful on probation.
Great. Thank you, Judge.
I will see you on Wednesday.
Yes, ma'am.
All righty. We're off record on this matter. Counsel, you and your client are excused. I'll see you on Wednesday. Thank you.
Yes, Judge. Have a good day.
You too. I need to go ahead. What is happening with the track matter? The state? I'm about ready to bring in the juror. Who's that? Oh, him. All right, let's approach on the jury matter and the Menchaca case. Who's that, man? Okay. With your client?
Pardon me, Your Honor.
Alrighty, let's go ahead and get on record on cause number 631-203, State of Texas versus Eric Matthew Menchaca. Parties, please approach and identify who's before the record. Who's before the bench, starting with the state.
Lane Han for the state.
Sergio Ibarra for Mr. Menchaca, Your Honor.
Are you Mr. Menchaca?
Yes, Your Honor.
Eric Matthew Menchaca?
Yes, Your Honor.
Let the record reflect that Mr. Eric Matthew Menchaca is in this court session and in the courtroom with his attorney. Alrighty, we're set. We have the jury outside. State you're prepared to go to trial.
Say this prepared, Your Honor, but I think that we've worked something out.
Defense?
That is correct, Your Honor. We've just recently conferred on this, and I think we've come to, after speaking with Mr. Menchaca about the offer, it looks like something that we would want to take, yes. We would agree to. It was an offer that had not been made previously.
Alrighty. And the paperwork is ready?
I can have it ready in no time, Judge.
Alrighty, because it's 9 o'clock. First of all, both of you were late, and so tell me why I should not hold you in contempt for being late.
Your Honor, I definitely do apologize, Judge. We are down an attorney today. So we're all covering different settings. I still have to be back up in the 175th to cover felony setting, but I believe Mr. Kalpas will be there for that one if we were starting the jury trial today. I sincerely do apologize, Judge. Perhaps I should have just checked in with the court first to let the court know what was going on.
We've had jurors waiting since 9 o'clock. State, what was your problem?
Judge, we typically on trial days are available on Zoom to confer before.
9 o'clock, the court ordered both parties to be here at 9 o'clock. Please understand you here at 9 a.m. on trial dates.
Yes, Your
Okay,
Honor.
Yes, Your Honor.
all righty, let's get that paperwork ready.
Very well, Judge.
And quickly, because I will not release the jurors until I take this plea.
Yes, ma'am. And Your Honor, just asking court's permission, may I have Mr. Menchaca sit with me at council table so I can go through the paperwork faster?
Oh, sure, of
Very
course.
good, thank you.
Oh, no problem.
Yes, sir. State, you have cause number 684955, State of
on Andrew Cabrera. Ready to proceed on that? State, I need you up here, please. Let's get on record. State is, court is going to, on this side, please, since this defense is not here. Court is going to call cause number 684-955, State of Texas versus Andrew Dixon Cabrera. Parties, please approach and identify who's before the court, starting with the state.
Ling Han for the state.
Good morning, Your Honor. Mark Braswell with my client, Andrew Dixon Cabrera, and we're ready to proceed.
Thank you, counsel. Are you Andrew Dixon Cabrera?
Yes, Your Honor.
Am I pronouncing your name correctly, sir?
Yes, Your Honor.
Are you the same that has been accused of driving while intoxicated with a BAC 0.15 or higher alleged to have occurred on the 14th day of May 2022 and classified as a Class A misdemeanor? Are you the same so accused, sir?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
I do.
Thank you. You may go ahead and lower your right hand. Court is going to start sharing the court's screen as the state is in the courtroom in person and defense is via Zoom. Mr. Cabrera, can you see this court screen?
Yes, ma'am. Yes, Your Honor.
Defense, can you see the counsel? Can you see the court screen?
Yes, Your Honor, I can.
And state, can you see the court screen?
Yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign that document, thus consenting to these proceedings by video conferencing?
I did, Your Honor.
State's video conferencing consent is made part of the record. Defense, on display. Give me 2 seconds. Is a document entitled Defendant's Consent to Video Conferencing. Mr. Cabrera, is this your signature where I'm circling the cursor?
Yes, Your Honor.
Did you sign this document thus consenting to plea by video conferencing?
Yes, Your Honor.
And counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor, I do.
Defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Cabrera?
More than 10 days, Judge.
Are we applying for probation? And if so, what type, please?
It's for deferred adjudication, Your Honor.
Mr. Cabrera, on display is a document entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document. This is the first page and this is the second page. I draw your attention to where I am circling the cursor in the middle of the second page. It states that you personally appeared before me today, and albeit via Zoom, you are the defendant in this case. I have sworn you in, and under oath, you're telling me that your application for deferred adjudication community supervision and the document entitled your personal data sheet, which is going to be attached as an exhibit to your application, is true and correct. Is that correct, sir?
Yes, Your Honor.
And do you need to, now keeping in mind that your, if your personal data sheet or the application is not fully complete, it cannot be true. Do you need to speak with your attorney before you answer this question? Or provide your response to this statement, that the defendant understands and acknowledges that any untrue statement in the application or the exhibit, the personal data sheet, may be grounds for denial or revocation of any community supervision in this case. Do you wish to speak to your attorney?
No, Your Honor.
And what's your response, sir? Do you understand and so acknowledge?
Yes, Your Honor.
I will sign the document, making it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
We have, Your Honor.
And defense, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
Yes, Your Honor, I am.
State, is there a law enforcement disclosure applicable to this case? And if it is, has that been complied with?
Your Honor, it is applicable and it has been complied with.
I will sign the discovery acknowledgement and making it part of the record. State, do you have any motions for the court's consideration?
The state would request, would move to alter and amend the information and proceed on an obstruction of highway.
State, what's the motion again?
Motion to alter and amend the information to include an obstruction count and proceed on that.
State, did you provide a written motion on that?
Yes, Your Honor.
Where is it?
I believe it would be part of that Adobe sign packet.
Mhm.
State, is this the state's motion to alter and amend the information?
It is, Your Honor.
Defense,
There's no objections to the motion, Your Honor.
regarding the state's motion to alter and amend the information, do you waive your 10 days to prepare?
Yes, Your Honor, we do.
Mr. Cabrera, whenever the information is changed, the information is a document by which we bring it to court. In that information contains the nature of the offense and the charges against you. Whenever that is amended, altered in any way, you get 10 days to prepare to defend the new information in there, the amended information. Your attorney has stated that he's waiving the 10 days to prepare. Do you join your attorney in waiving those 10 days to prepare?
Yes, Your Honor.
Defense, any objections to the state's motion to alter and amend the information to add a count two?
No, Your Honor.
Without objection, that motion to alter and amend to add count two is granted. And along with consideration that you and the defendant have waived the 10 days to prepare. State, any, excuse me. Now, Mr. Cabrera, this is, I will sign the motion. And it is ordered and made part of the record. This now is the amended information with a count two added, along with the complaint. State, any other motions for the court's consideration? What other motions you have?
Judge, the state also has an exhibit for the court's review just for the purposes of this hearing.
State, are you waiving and abandoning the 0.15 enhancements along with count one and proceeding on account two?
Yes, Your Honor.
Defense, what say ye?
We have no objections, Your Honor, and we're proceeding on count two, obstruction of a highway.
Yes. A class B.
Yes, Your Honor, that's correct.
That motion is granted. State, any further motions?
No further motions from the state, Your Honor.
Did you mention something about a seeking to enter State's Exhibit 1 as for admit it?
Yes, Your Honor.
Is this State's Exhibit 1?
It is, Your Honor.
Defense, what say ye to state the admission of state exhibit 1 for the purposes of this hearing?
No objections, Your Honor.
Without objection, that state's exhibit 1 is admitted. Mr. Cabrera, this is state's exhibit 1. It indicates here that you intend to plead guilty on this document entitled Waiver of Objection to Amendment of the Information and the Rights Stipulations of Facts and Judicial Confession. This being a 2-page document, that being the first, and then this being second. I see where your attorney and you have signed it. Next is motor vehicles in the household. It indicates here that you hereby swear that you do not own or possess a motor vehicle, or nor does a member of your family or household where you live own or possess a motor vehicle. You have signed that.
Okay. Excuse me, Your Honor. I apologize, Your Honor. So I don't know how that got clicked saying I don't own one. In my personal data sheet, I filled out the one vehicle that my household owns and it's under my name. I gave the license plate number, the make, model, year, everything. So I'm not sure how that shows that I don't own a vehicle.
He does own one, Your Honor.
Well, here's your signature.
Yes, Your Honor. I was doing it on a phone. We got it last minute and it may have just been, my thumb accidentally grazing it, but I did submit the personal data sheet that does fill out the vehicle information, as did my attorney.
All right, so you're telling me that you should have checked this radio button and thereby swearing that you, the following motor vehicles are possessed or owned by you, a member of your family and household where you live, and place your address here along with the description of the vehicle and signature here. Is that what you're telling me, sir?
Yes, Your Honor. My apologies.
Not a problem, sir. Will you be able to fix this once you come in to provide your fingerprints?
Absolutely.
Okay, thank you. So here's your plea bargain document. And then here's a waiver of appeal and post-conviction remedies, whereby you have signed it. And it is indicated here that you understand that you will be entering a plea of guilty.
Yes, Your Honor.
And then here's another oath, whereby you are telling me that you personally appeared before Attorney, Lynn Han. You've changed your name to Lynn Han on this document.
Yes, Your Honor. I've been signing that way for a while now.
So you're the defendant in this case?
Oh, no, Your Honor, I don't. I'm sorry, where does it say?
Right here.
Oh, no, Your Honor. I don't know what technology thing occurred there. We don't go through and enter every single field. It auto-populates a lot of them.
This is the first time I'm seeing this.
Yeah, it's the first time for me too, so I don't know what's happened to it.
Defense,
Your Honor,
you
my
entered
client,
the prosecutor's name here.
I don't know how that happened, Judge. My client signed down at the bottom as defendant, so
Yeah.
we know it's him.
Okay. Okay, sir, you will be able to go ahead and correct this. This is a big correction that needs to be made, okay?
Yes, Your Honor.
And make sure all the corrections you initial it when you come in.
Yes, Your Honor.
However, this is supposed to say that your name, that being Andrew Dixon Cabrera, and you came in, after I've sworn you in, you're stating that you are the defendant in this case and all the facts in the above stipulations and plea agreement are true and correct, specifically including the documents so labeled. And I've read each one to you.
Yes, Your Honor.
Label. And you've signed it. That's your signature, right, sir?
Yes, Your Honor.
Okay, I will go ahead and sign it, making it part of the record. Also, here is the order that and indicates here that you're going to go ahead and plead guilty. I am going to go ahead and sign that, making that all part of the record. State, do you have any other motions for the court's consideration?
No, Your Honor.
Defense, do you have any motions for the court's consideration?
No, Your Honor, I do not.
Mr. Cabrera, I draw your attention to the document entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a 2-page document. This is the first page, and then this is the second page. With your signature, is that your signature here that I'm circling?
Yes, Your Honor.
Okay. Did you go over this 2-page document with your attorney?
Yes, Your Honor. I believe we did.
After reviewing, you believe you did. After reviewing the document, this 2-page document, did you freely and voluntarily sign it, sir?
Yes, Your Honor.
So with your signature and testimony, you're telling me that you understand everything in this 2-page document as it was reviewed and explained to you by your attorney?
Yes, Your Honor.
Are you satisfied with the representation of your attorney, sir?
Yes, Your Honor.
He's done very well by you, sir. He has reduced this from a Class A to a Class B misdemeanor, having the 0.15 enhancement waived, and even further reducing this from a DWI to an obstruction and as a regular Class B misdemeanor. He has done tremendous work for you, and I'm glad that you are satisfied with his representation. He's a very experienced, as you can see, attorney, one good attorney. And sir, this now is a Class B misdemeanor. Did he explain to you the range of punishment associated with the obstruction?
Yes, Your Honor, he did. Up to 6 months in jail and up to a $2,000 fine.
It appears that you understand that, sir. Did he go over with you your constitutional rights?
Yes, Your Honor.
And you understood those?
Yes, Your Honor.
With that understanding, sir, do you freely and voluntarily give up your constitutional rights?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
I will prove your jury waiver. I am going to sign it, and you will no longer be able to have a jury trial in this case, as I have made it as part of the record. Counsel, do you believe that your client is competent to enter into a plea today?
Yes, Your Honor, I do.
With the amended information, were you able to apprise this defendant of the nature of the offense and the charges against him?
Yes, Your Honor, I was.
Do you and this defendant waive the formal reading of the amended information?
Yes, Your Honor, we do.
State, what is your punishment recommendation in this case?
The state is recommending 24 months deferred adjudication, a $250 fine, court costs, 48 hours community service restitution, DWI education, uimpact.com, a TAP evaluation and all recommendations from it, ignition interlock for half the term, and that the defendant agreed not to apply for early termination.
Counsel, is that your understanding of the state's punishment recommendation to the court?
Yes, Your Honor, it is.
Mr. Cabrera, is that your understanding of what your attorney has worked out with the state on your behalf in order to be able to dispose of this matter for you today?
Yes, Your Honor, it is.
With that understanding, sir, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
You're pleading guilty because you are guilty and for no other reason than the fact that you are guilty?
Yes, Your Honor.
I will accept your plea of guilt, finding that it is intelligently and freely made and that you're competent to enter into such a plea. Counsel, what, if anything, do you have on behalf of your client and why I should consider this plea?
Well, Your Honor, my client, Andrew Dixon Cabrera, is someone who doesn't have criminal history. Mr. Cabrera is married and has two little sons with his wife. Their ages are 2 and 6 years old. He's got a beautiful, stable family. He's the primary breadwinner, and he is an airplane mechanic at Boeing. And, you know, part of the reason we had to work so hard with Ms. Hahn on this plea bargain was to ensure that it would not result in him being prematurely terminated from his stellar career at Boeing here in San Antonio. So we've been able to work this deal out with her, and we're very satisfied with where we're at. And I know that Mr. Cabrera will be the model probationer. Judge, I can tell you every time we've had court, he's arrived at my office an hour and 15 minutes before you call the docket. He's very punctual. He has been nothing but remorseful since the moment this happened. He was extremely polite and respectful to the officer, Officer Ellis with SAPD. And this has definitely opened his eyes. And I want the court to know that this is a person who will not come before you again. He has learned his lesson, believe me, and he has way too much to lose to ever take a chance and mess up. And I don't think he will, Judge. I really believe Mr. Cabrera is going to do the right thing by the court. And I think you'll see that in the coming months, that he's a man of his word, and he's going to step up, he's going to own it, and he's going to do the right thing.
Counsel, can you address the 1622 that's associated with your client?
Yes, Your Honor. I've talked with my client, and that will not be an issue here. He has a very strong, stable family support network, a great career, a great wife, a great set of friends and family that support him. And there's nothing that the court needs to be concerned about with that. I discussed it at length, and it's not going to be an issue for the court, and it's not a concern right now, Your Honor.
State, any concerns regarding this scene 22 associated with this?
No concerns.
Council, thank you very much. That was extremely helpful.
You're welcome, Your Honor.
Mr. Cabrera, whom do you live with?
My wife and my two kids, Your Honor.
Whom?
My wife and my two children,
What is her name?
Marissa Cabrera.
Is that Marissa?
Yes, Your Honor.
How many vehicles, does she have a vehicle?
No, Your Honor, not at the moment.
I'm sorry. So how many vehicles in the household?
Just one. I have motorcycles, but they're not currently running. They're projects.
It's they're motorized, correct?
Yes, yes, Your Honor.
How many is that?
I have two, both of them out of commission.
Make sure that those are listed.
Yes, Your Honor, I will. And then I do have the Chevy pickup truck that I mentioned as well. That one does run. That's my daily driver.
Excuse me. What vehicle, describe for me what vehicle, year, make, model that we'll be placing the ignition interlock on?
Yes, Your Honor. It's a 2009 Chevrolet Silverado.
Do you have the ignition interlock on your vehicle at this time?
No, Your Honor.
Say, what was the BAC in this case?
0.222.
Yes, Your Honor, that's correct.
Say, do you have any objections with this defendant being referred to the Bear County Gives Back program?
No objection, Your Honor.
Your Honor, could you please repeat the name of that program?
Bear County Gives Back. Are you familiar with it, counsel?
No, Your Honor, I'm not. But it sounds like a good program, Judge.
Counsel, I will have the CLO, she's here, and she will, I will place you in a breakout room with the CLO, and she will go over that with you and your client. And I will speak to it more in a minute, okay?
Thank you, Judge.
Yes, sir. Counsel, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor, there's not.
Mr. Cabrera, although there's sufficient evidence to find you guilty in this case, I am going to withhold my finding of guilt, and I'm going to place you on 24 months of deferred adjudication community supervision for obstruction of highway intoxication.
Yes, Your Honor.
Okay. The Community Supervision and Corrections Department, otherwise known as probation, will supervise and monitor you on behalf of this court for these following conditions: $250 fine plus court costs, 48 hours of community service restitution. I am going to refer you to Bear County Gives Back program for satisfaction of only the first 40 hours of that. You're responsible for the full 48. DWI education, uimpact.com, TAP evaluation, and parenting class. You will install the ignition interlock within 10 calendar days and maintain it for half the term of your probation. There'll be no early termination of probation in this case. Regarding affidavits, I will require one affidavit from you within 10 calendar days. That will be that you will not drive any vehicle that is not equipped with an ignition interlock. You have indicated that you do live with your wife, Marisa Cabrera, but you're saying that she does not have a vehicle at the moment. If she does acquire a vehicle, she will need to provide an affidavit that she will not allow you to drive that vehicle under any circumstances, and that vehicle will need to be identified by year, make, model, color, license plate number, and last 6 digits of the vehicle identification number. I am going to require that your CSO provide a status report in 2 months and conduct on how you are while you're doing on probation, and conduct a field visit. You will need to also identify in your affidavit that you will not drive any vehicle that's not equipped with ignition interlock. That includes your motorcycles.
Yes, Your Honor.
And you probably, with those motorcycles, you're stating that they're inoperable. You'll need to get a third-party verification attached to your affidavit that they are inoperable. I am going to set your supervision fee at $50. State, did I cover everything for you?
You have, Your Honor. Thank you.
Counsel, anything further on this matter?
No, Your Honor, there's not. My client will report the probation in person today. Am I correct?
Not necessarily, sir. That could be a possibility. However, we'll need to go ahead and complete the paperwork on him. So we will go ahead and see about that. I'm going to need him need to finish the plea and then I will discuss further with you.
Okay, thank you.
You have nothing further?
No, Your Honor.
Mr. Cabrera, with regard to trial court certification of defendant's right to appeal, this has been a plea bargain case, and I am going to certify that you have no right to appeal. You'll be able to pick up the copy of this certification when you come in to provide us your fingerprints. When will you be able to go ahead and do that, sir?
As soon as you need. Your Honor.
Tomorrow?
Tomorrow? I can do it today, tomorrow, whenever you'd like.
May be able to get you fitted in today, sir.
Okay.
You need to come to the courthouse between the hours of 2 p.m. and before 4:30 p.m., sir. You're coming to County Court at law number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We are on the first floor of the Kadena Reese Justice Center. If you do not come in today, sir, to provide your fingerprints, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, Your Honor.
Now, with regard to the Bexar County Gives Back program, as I mentioned, CLO Jennings will be glad to explain that full program to you. This is what you need to know from me, I provide that as an alternative for you to complete 40 hours of community service restitution. You have been assessed 48. If you do not wish to complete that, participate in that program, you do not have to. You're still responsible for the community supervision, community service restitution, okay?
Yes, Your Honor.
So I make it optional. I have several methods by which you can satisfy that community service restitution. Your probation officer will go through it with you, okay?
Yes, Your Honor.
Now, Mr. Cabrera, I do wish for you to go ahead and listen to this. You're in a position of great sensitivity. A lot of people depend upon your skills, especially those pilots who are flying those airplanes. And you know how critical it is that you cannot make a mistake while performing your duties and your job. And I'm especially sensitive to it, as I spent a lot of years in an airplane and plan to go ahead and continue. Your attorney has said some very, very, very good things about you, very nice things, and he has worked very hard for this, keeping your career and you in mind. I'd like for you to show the appreciation of what your attorney has done here for you, okay? By being successful on probation. It is so imperative for you and your family, and to honor the work your attorney has done. I appreciate your skills. It's not easy to acquire those particularized skills. And I appreciate the contribution that you continue and will continue to make to your community and your family. Please go through all these classes, listening to them and taking them seriously, as I am sure that you indicate here that you have 2 kids who will depend on you, not only for support, but for what you do to them as a father, okay? What you do for them and the example that you provide them. Thank you very much for coming in and taking care of this matter. And now I'm going to place you in the breakout room with CLO Jennings, and we'll see you this afternoon, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Thank you, Mr. Braswell, for your advocacy and representation in this case. Well done.
Thank you very much, Your Honor. It was a pleasure.
I'm going to stop sharing my screen and we're off record on this matter. Could you please move him in with CLO Jennings? Thank you, State.
Your
Thank you,
Honor.
appreciate it. Did you move her? Is Officer Jennings, did she move? Did you move her? Oh, okay.
Judge, I was gonna
Good morning,
run
sir.
away to the men's room. Do I have time or should I stay and handle my?
Oh,
business?
no, I just saw that you were there. Sorry about that. Go
It's okay.
ahead. Oh, but if you need to go ahead and run, you can. I was just going to check with the other.
Oh, we can do mine now if it's fine. I mean, I'm ready.
Okay.
He's here. He's wearing the black shirt with the cross.
Hi, Mr. Alvarado. He checked in, your client checked in. Thank you. Now, this is the one that have you had an opportunity to go through with probation on this, discuss with probation on this matter?
Your Honor, in this one, we didn't talk to probation. I think the only issue that there was, and the court can correct me if I'm wrong, he had originally stated he wanted to appeal. So the case was sort of pending in limbo.
Right.
Since then, we visited and he has indicated he does not want to appeal. So last week, I filed a notice and actually was just accepted or accepted this morning.
Oh, wow.
And it basically says, I wish to waive my right to appeal and continue on probation.
Okay. Allow me to go ahead and get that, see if the clerks got that, okay?
Okay.
Hey, can I get clause number 561503? I thought you were gonna bring all of the other cases, other court files. Oh, those first and then those others. Yeah, bring the rest of them if you fold them, okay? Thanks. Attorney Adalpe, let me go ahead and put you in with probation to discuss the matter while I'm getting the file, okay? All right.
Yes, Judge.
And basically, and kind of filling CLO Jennings on this matter. It's been pending for quite some time.
Okay, Judge.
Okay. Let's go ahead and move Attorney Adalpe in with CLO. Mr. Trevino, I need for you to contact your attorney, see where's that, okay? And you
yes.
need to, yes, yeah, and you need to know how to unmute and mute your mic, okay?
Not a problem, ma'am. Sorry.
Okay, thanks. Sure, absolutely. Ms. Luna, I need for you to, if you haven't, I haven't turned on the Skype, you may have communicated.
On Mr. Garcia, Judge? Or?
He had shown up. I had seen him. Just need to know where he's at. No, the other attorney's on the docket.
Okay, give me 1 second.
Excuse me, Your Honor.
Yes, sir.
This is Jonathan. I would have to hang up and call him because I'm using a phone. It's not a laptop. So it'd be
Make
harder
sure
for
that
me.
make sure that it is charged, it's charging, so you don't run out of battery, okay?
Not a problem. I have it charging right now.
Okay.
Judge, Mr. Garcia will be logging in shortly with us.
Mhm. There you have it, Mr. Trevino.
Excuse me?
Your attorney is going to be logging in shortly.
Oh, okay, okay.
Ms. Luna, I need Monica Guerrero, Brenda Levenstein, and Joseph Acevedo.
Yes, Judge. The only one that I haven't heard back is from Mr. Acevedo, but let me go ahead and give him a call. Ms. Guerrero and Mr. Staten are both in felony courts right now, and Ms. Brenda Levinstein is also in a felony court.
Okay. Did you get the filing? Who's it? Is it this case? Yes. Is this what he just filed this morning?
Yes. I just found this one. And then 612.
Is that it?
That's all that came in. 63123. This needs to go in there as well. It's a discovery.
Okay.
Thank you.
Sure. Yes.
Of course, we had thought that we had an agreement here. We understand the board not wanting to accept the offer. We completely understand it. Regarding whether to proceed to trial or in the procession to trial, there was only one issue I think that I discussed with the state this morning regarding the discovery issue. From my understanding, there were some videos or dash camera or code videos of this particular stop investigation. It was not put on the e-discovery portal. We had We didn't know if the state had them or if they were getting them. Our understanding is the state uploaded them. They themselves found out about them and they were uploaded on Thursday afternoon. And so we received them that evening. I have not had a chance to look at them since the holiday. And so that was an issue that we wanted to present to the court. Obviously, my client has not had a chance to really review them with me or any of those things. And so, of course, that's something, an issue that I had to bring to the court's attention. Talk to the state about that. And hoping that the agreement would obviate the need to do all of those things, except for just looking at them cursorily. But it is something that I would probably have to bring to the court's attention. To this particular trial.
I am so sorry. Let's go, you're gonna have to go through that again. Let's get back on record. Where's your client?
This is the invitation for the portrait unveiling.
So in the afternoon of when?
It's, I'm sure the exact date, it was the 10th of November, yes.
So you discovered these on the 10th of November? Okay. In the afternoon. And you uploaded them?
Yes, sir.
And why is it that you did not have these this discovery?
It was not in our system, and I did not investigate why it did not appear in the system before.
But in preparation for a pretrial conference hearing, did you look to see that the whole discovery had been uploaded?
But this one, I just did not know to look for that specific video. That's my mistake.
Specific video, so it's one video?
Your Honor, as I said, there were more videos specifically for the dash cam videos, and they were not in there.
No dash cam videos whatsoever.
That's correct, Your Honor.
And the nature of this offense, State? What's the nature of this offense?
The class, it's a class,
What is the offense, State?
what's driving while intoxicated, right?
Would there usually be an indication that there may be videos with that?
Yes, Your Honor.
What's the agency involved?
It's a San Antonio Police Department.
Has the San Antonio Police Department been equipped with video, body cams, dash cams for quite some time?
Yes, Your Honor.
Defense, please continue.
And so, Your Honor, that was our understanding. It was uploaded as soon as the state discovered those particular videos. We have reviewed, defense has reviewed the body camera videos, which were provided by the state ahead of time or timely. Of course, in our conference, in the pretrial, the PTC conference, it was our understanding that the state had all evidence that, that they were aware of at that point in time. Of course, in situations like that, if the state does produce certain pieces of evidence, of course, that's their ongoing obligation, and they are aware of that. We save, or at least retain our ability to object to any evidence that is not produced timely. And that's essentially what we're doing now, Your Honor. Of course, it's better if we have certain pieces of evidence, and if the state does not timely provide the evidence, then we seek to at least, I know our remedy under 3914 is either to ask for a continuance to prepare, or if it's not quite timely and time is sort of run out, to ask for the exclusion of that evidence and the potential for that any mention of that specific evidence coming in. Of course, that is something that we would object to at this point, because I do not believe that it is the fault of the defense that this has not been produced or was not found ahead of time. We did timely request have our discovery request in under Michael Morton pretty early in this case. So it's something that we felt necessary. We thought maybe perhaps we had an agreement here. And so of course that was, as I mentioned to the court, something that would obviate that need. It seemed like something that we could come on both sides to agree to, but the court in its wisdom has indicated they would reject that plea. And so this is something that we had to bring to the court's attention as it's under Michael Morton, under 3914, the Code of Criminal Procedure of Texas, Mr. Menchaca's right to make that objection.
And just for the record, defense, you do not have a motion for continuance on file, do you?
No, Your Honor. I did find out from the state this morning that those videos had been uploaded. I think what happens is when they upload it, it is sent to a general email for the firm. I don't know exactly what time it was uploaded or we got the email, but I can tell the court that I was not in the office at that point in time whenever it was done, and I was made aware of it this morning.
And so what are you asking at this time?
I do believe, Judge, that the the traditional remedy for this is to request first the court for a continuance in order to have an opportunity to review those. There is as well the objection to and asking to strike the evidence and any mention of the evidence that it would depict. But I don't know that just exercising professional courtesy and just being humble before the court, I think that I first would ask for the less onerous remedy and then proceed from there. However, Judge, it is also very important that I also assert Mr. Menchaca's right to a speedy trial. It has been some time now. Requesting a continuance, while it is the professional and thing to do, I have to look out first and foremost for his rights. And so by having him be here now after a few years, and this evidence coming to light brand new, I think the thing I must also ask for is that if the court says that we must proceed, then I think the sanction or the remedy at law would be to strike that evidence, and I think we can go so far as to ask that it be struck from testimony as well, because we have not had adequate time to prepare, and I think it would inhibit his ability to have a speedy and fair trial.
State.
All I got is that the state was not acting in bad faith and not disclosing this evidence ahead of time. And I think a continuance would be appropriate.
State, you represented to the court on 1st of September 2022 that you had no discovery issues or concerns.
Sure.
And so if the discovery wasn't there and you were here prepared for a hearing, how is that not in bad faith?
Your Honor, I was not aware that the state was missing my evidence.
But we had a hearing and a pretrial conference hearings. When you tell me, and I document, that you have no discovery issues or concerns, court assumes that you have checked and represented to the court truthfully that you had no discovery issues or concerns, meaning that you had checked the discovery that was made available and you truly didn't have any discovery issues or concerns and responsibilities. So how is that not acting in bad faith with the representation that was made to the court and to defense?
I have to say that it's my lack of experience in practicing in this jurisdiction. I just was not aware that that was something I should check for. Sorry on that.
And so you usually don't, so somewhat of a distinction. However, you have a partner that also practices and represents the state, correct?
That's right.
Okay. ADA Han?
Stronger.
Lynn Han Martinez. ADA Victor Hernandez has indicated that he did not check for discovery due to lack of experience or practicing in this jurisdiction. Counsel?
There are several places that videos are uploaded to. One that I've never even accessed since I've been here, and that's where the videos were. So we do have videos, we do have dash cam and body cam that have been uploaded and have been made available to defense prior to today's setting. It was after speaking with our chief that we discovered this other avenue that dash cam is uploaded to, that what I was not aware of even, and now we are aware of it. So it's literally a situation where as soon as we found out Thursday afternoon, later in the afternoon also, that we requested it be uploaded and made available to defense counsel.
Well, what perplexes me is that you announced ready. State.
And Judge, that was an announcement because we had everything that we were aware of.
And so,
And there are videos that are uploaded and made available to defense that we also have, but we did not know the existence of these other ones.
so how was it that the existence of them came to your attention?
Because we were talking about this case with their chief, who then looked it up in the system, in a different system.
So prior to going ahead and preparing for a pretrial conference hearing in which the discovery of this and the court admonishes and orders the parties to ensure that discovery does not impede the execution of this trial on the set date, you're telling me that you were not prepared at that time and did not make an inquiry of your chief or as far as the dash cam videos are concerned?
Judge, our communication with our chief was not about the existence of discovery. And again, we can't know about discovery that exists that we're not aware of. I don't know how we're supposed to know about everything that's available for a case when we aren't aware of all the places it could be. It's not one unified system, unfortunately. And again, it's something that I may not even have access to still. Literally, no one has told me my login information for it. And this is a thing I just found out about on Thursday.
And Your Honor, if I may respond just briefly. I have a lot of respect for both of these prosecutors. They have been in communication with me, and I don't want to put anything on them specifically. What I can speak to, Judge, is that as is made clear, the office itself is having these issues with finding this evidence or what have you without perhaps, this is a speculation on my part, perhaps proper training on where one can find these things on the system. Of course, but I still have to be concerned primarily with Mr. Menchaca's, and I believe the court does as well, Mr. Menchaca's rights and the inhibition of them. I think while we are talking about the potential for bad faith, and there's different avenues by which to assert that, I think first and foremost, what we have here is a situation in which Mr. Menchaca's speedy trial rights, which aren't under that same standard, Judge, would be inhibited by having evidence produced just now. I think the objection that I would make, or the request I would make, and I believe I can make this orally because it's a constitutional request objection, is that the case be ruled to be dismissed for lack of a speedy trial on this case. Because in order for me to do my job and be effective counsel to Mr. Menchaca, I would have to request a continuance, thereby adding more time to this issue in order to do that. So I'm now in a conundrum. I asked for the time to be effective. It pushes out his speedy trial rights even further, and he's already been waiting this long. So if I'm going to make an objection, Your Honor, I believe the strongest objection would be I'm asking for the case to be dismissed for lack of a speedy trial for Mr. Menchaca, based on the circumstances.
Say,
I'd like to confer with both counsel.
of course. We will go ahead and suspend the record at this time. Please go confer.
Your Honor.
Attorney Garcia, good morning.
Good morning, Judge. How are you doing?
Fine, thank you very much.
So I have John Trevino. He is present, Judge. If you can throw me into a room with the prosecutor and the CLO, that'd be great.
Okay.
Judge, before we lose the CLO, I'm going to need Officer Jennings, if you don't mind, Judge.
Oh, I thought you guys were conferring.
We did confer. We're back. We just wanted to approach the court and let you know an update.
Oh, okay. Oh, you mean before I sent her to talk with Attorney Garcia?
Yes, I don't want to lose her because I need her.
All righty, go right ahead.
Judge, I conferred with Officer Jennings. It's my understanding that in the court's discretion, the way that we would proceed if you approve him being put back on probation is that we could just set him up for a plea in the next, 2 weeks. And basically it would be almost as if everything is started anew. And we could get him to sign all new plea paperwork and just do it clean that way, Judge.
If that would be the best way to proceed, why cannot we, is there a reason why we have to wait 2 weeks? Why can't we get that done this week?
This week's crazy bad, and next week I'm actually putting vacation notice. I'm going to be in Mexico. So
It sounds like a personal problem.
it's a very big personal problem, Judge. So if the court would allow, I can give you like 4 or 5 dates that would work. However you want to do it, Judge.
Okay, let me go ahead and place you in the breakout room with the and you can appreciate the length of time. That's my concern that has gone with this. Okay, that has gone on with this. So, so I like to get it done sooner than later.
I come back into the country on the 27th.
Okay.
The absolute quickest would be the 29th because I'm in federal court in Del Rio on the 28th, but the 29th is a Tuesday. That's good for me.
All right. That's the soonest.
Yes, because I fly out and I land on the 27th at night back in Houston. And then the following day I have to drive to in-person federal court in Del Rio on the 28th.
Okay, so 29th, we have it. Put you in a breakout room with the court coordinator to go ahead and get all of that paperwork done for you.
Thank you, Judge. After I'm with Herrick, may I be excused? May we both be excused?
Oh, yes, I am going to put you in with your client and that will take care of that. You guys are excused from there, okay?
Thank you, Judge.
Thank you. And let's go ahead and move Attorney Garcia in with CLO Jennings.
Thanks, Judge.
Yeah. Mr. Alvarado, accept the invitation. Okay, great. Attorney Levingston, she was just here. Attorney Geyer?
No, I'm just waiting to see this time.
Oh, okay. Did Attorney Levinstein say anything to you before she took off? Okay, that's okay. Deputy, please let the jury know, the jurors know, it just be a few more. Or should we let them go to lunch and have them come back at 1 o'clock? Yeah, let them come back at 1 o'clock after lunch. Oh, yeah.
Excuse me, Judge.
Okay. Yes, who's speaking?
This is John Trevino.
John, let me talk to the judge,
Oh,
okay?
okay. I'm sorry. I didn't know, 'cause I just heard her say
Yeah.
something about 1 o'clock and I was like, uh-oh.
Right, just mute yourself.
Okay,
Thanks.
thank you.
Judge, on Mr. Trevino's, I conferred with the CLO. Can I get in a room with the prosecutor, Judge?
Okay, I will, but I believe that they're conferring out in the hallway or in the back room with each other on a trial matter. So it may be a minute or two, sir.
All right, thanks, Judge.
Appreciate your patience. Attorney Levenstein, I thought I saw you in the courtroom. Good morning.
Yeah. Yes, well, I saw you were busy, so I thought I'd just go on the Zoom.
Okay, not a problem. What are we going to do with all these cases and your client?
I just have one. Oh, well, he's got three. You're right. Joe Frank Jaramillo.
Yes.
He contacted me early this morning and said that he's not feeling well and that late last week he was with some people and one of them tested positive for COVID over the weekend. And he says he's got a cough and a runny nose and that his stomach is really killing him. So I don't think we should do any plea today.
So has he gone to the hospital?
No, but he's going to get a COVID test.
He's going to go get a COVID test?
Yes.
And when would he get the results of that?
I don't know. I'll ask him.
Okay. And it shouldn't be that home test, please.
Oh, so that you want him to get the more serious, the more thorough.
Well, yes, because
Yes.
I've heard as far as that home test is concerned, it's not as reliable, maybe an indicator, but it's not as reliable as it. Mhm.
Right, okay. Okay. Well, then I can let the court know once we get the results.
Okay, so you guys want to be recalled for tomorrow?
I don't know. I guess we'll wait and see. I mean, I don't know if he's gonna be able to get the PC. What is it, PC? I know he has to go to only certain places to have that.
The plea
frozen.
can be done via Zoom.
Oh, all right. Well, I don't think he should have to enter into any sort of agreement if he's not feeling well and not clear thinking, you know?
See him tomorrow, see how clear thinking he
We
is.
just get a reset for 2 weeks?
Tomorrow.
Okay. If you insist.
And then he can go ahead and be able to present that he has at least gone to get tested. And this
Right.
gone to get tested, and then we'll just wait for the result. I mean, if that's what he wants to do.
Okay.
So.
Okay. Thank you.
All right, so we'll see him tomorrow.
Will it be the same Zoom link as today?
Yes, ma'am. Yes, he can appear by Zoom. It's the same Zoom link.
Okay.
Yes.
Okay. Thank you.
Thank you. All righty, tomorrow then. Time to feel better.
Okay. Yeah. Thank you.
Attorney Levinstein, if he does not appear tomorrow, today I mark him as failure to appear. If he does not appear tomorrow, there will be a warrant issued. Please let him know that. And he can appear via Zoom. Sure. On the Nantucket case?
Yes.
Also, Attorney Garcia, David Garcia is waiting to confer with one of you.
Mr. Garcia, did you want to get in a breakout room?
Okay, could you go ahead?
That'd be great. Thanks.
You got him?
Judge, I'm back from the breakout room. Would you like an update?
Yes, please.
So on John Anthony Trevino, Judge, case number 313136, the state is going to be filing a motion to withdraw and terminate him unsatisfactory.
We'll have a hearing on that, right? We're set for a he is on bond, right?
He is, Judge.
We'll have a hearing. In fact, ADA Lin Han, you're named throughout all of the obstruction paperwork as a defendant.
I don't know what has happened. I'm trying to, I haven't had the time to try and look at what is happening.
Even in the amended information, the actual information itself, you're named as the defendant.
I don't know what is, what the cost.
Judge, are we talking about my client's case, John Anthony Trevino?
No, I'm so sorry. No, I was looking at, I was trying to finish up something I was, paperwork I was handling. And I just noticed that,
At the beginning, though, it is correct, right? It's just.
it's throughout the,
I mean, like on the first several pages,
yes, this is only with the,
the obstruction part.
yes, the state's motion to amend the information. You're named as the prosecutor and the defendant. Congratulations.
It's bad news for me.
Well, I don't know. All you gotta do is just now be named the jury and the judge. You're all set in the defense.
Trying to behave and it just goes back on you.
Okay. Let me just tell him to bring that information up. Okay. Counsel, Attorney Garcia, can I have you get in with the court coordinator and get an trial court certificate of defendant's right of appeal, please? Unless you have it ready. Okay. Come in with this court coordinator, please.
Good morning. Good afternoon.
CLO Jennings, do you have the, you've sent me the documentation on defendants, on John Trevino? CLO Jennings?
Yes, Your Honor.
Yeah, you've sent me the paperwork on Trevino?
I'm filling out paperwork right now.
Okay, all righty. So what we're going to do is we're going to go ahead and break. Court's going to go in recess until 1 o'clock, okay?
Okay.
Could you go in the breakout rooms and let them know we're in recess until 1?
Recess till what time?
1 o'clock.
Recess till 1 o'clock.